Well, thank you, Delegate Embry and members of the subcommittee. It's good to see all of you. Very simply, this bill was before the Judiciary Committee last year. It was passed out of committee and passed the House. It didn't make it across the finish line in JPR because it was sort of at the last minute in the session. What this bill does is it repeals, it's very simple, it repeals the restriction on non-citizens who are not green card holders serving as personal representatives of estates in Maryland. Maryland is the only state in this region, DC, Virginia, Pennsylvania, Delaware, West Virginia, that has this restriction. And what it means is that there are people who are living here in Maryland who have either someone named in their will or they're someone who has priority to serve under Maryland's intestacy law who cannot serve because they are not citizens. And we want to repeal that restriction because it will let, again, someone's named PR in their will or their next of kin, whether it's a spouse, children, et cetera, handle their estate for them instead of having to go through the time and expense of hiring an attorney, which in many cases can be cost prohibitive. I
Thank
think
you.
that's as simple as I can make it.
I
Thank you.
appreciate it. Are there any questions at this stage, members, or the next I would turn to our MSBA representative to describe their concern. Yes, Delegate Valentine.
Thank you, Madam Chair. And I was going to ask the delegate, but I can ask Mr. McFarland. Thank you first for that synopsis. Is there any changes between this year's version and last year's version to this point, to your knowledge? I don't think there is.
The final version that was passed last year is the version before you, Delegate Valentine.
Thank you, Mr. McFarland. Thank you, Madam Chair.
Thank you. Are there any other questions? No. Mr. Bornstein, would you like to describe the concern that you raised?
Okay. Yeah, thank you. And thank you, everyone. So we brought this to our legislative committee, and there was really overwhelming concern by everyone about allowing a non-citizen, non-resident, so theoretically somebody who never even stepped foot in the U.S., taking legal control over property or accounts in Maryland. And should they take the money or wire an account abroad or whatever, there would be very little legal recourse to recoup that. And that really is our main concern. I want to say that with the backdrop of we all want equal justice for everyone, and we appreciate Byron, what you said, and I know what Megan's concerns about MVLS, and we don't want to create roadblocks, and we don't want to create expense for decedents who, for situations like that. But what we would like to do is have more time to study this. We think that we're aware that in other neighboring jurisdictions, they allow non-citizen, non-residents, but we believe that there are safeguards or other safeguards and other provisions of the code that may offer some protections of the things that we're concerned about. So what we would like to do is have time to study this, work with the register, work with MVLS, work with everyone, and come to a bill where we can all be in agreement and supportive of and pre-file for next year. And that really is what we would like to do.
Well, if I may ask, I'll start asking a question. As I read it, what's currently section 6, but would be 5.
Yeah.
Already, so that exists for non-residents of the state, requiring.
You either have to be.
So wouldn't that cover most of your concerns? I mean, that's existing law, the requirements of the person's not a resident of the state.
You have to either be a citizen or a permanent resident, so a green card holder. And
no, but I'm saying the section that requires the any non-resident, that will remain that will remain. This is not touching the provisions, the added protection for any non-resident of the state. Is that correct?
No, I don't think so. I mean, wait, explain what you're saying.
So what is currently number 6? So we would be eliminating section 4,
yeah,
C, but section, what is now 6, but would become 5, applies to all.
Oh, yeah, that would,
residents.
so,
So that is a protection that would apply to a person, whether they're living in Pennsylvania or living in
yes, yeah, correct,
Poland. Okay.
correct.
Are there other questions from members? If not, I'd like to ask Ms. Good and Mr. McFarland to respond to those concerns. Okay, whoever would like to go first. Ms. Good or Mr. McFarland, if you could respond and possibly focus on the protections that exist.
Yeah, I'll briefly respond. So the protections I wanted to identify, you've already named one, the fact that there already is that requirement for non-residents to name a resident of Maryland as an agent for service. The other protections that exist, there are requirements for bond. Those requirements still apply. So this concern that someone would take the money and run, anybody designated as PR would still need to meet any bond requirements. And additionally, the laws that are in place to establish priority for personal representative also still apply. So if there, is family, local, et cetera, I think realistically, the situations where you would have a non-resident, non-citizen serving as personal representative is likely a situation where there truly is no other family, local.
And I'll just, I think Ms. Good kind of summarized it, but I'll just very briefly. Number one, I want to say, like, we appreciate the bar. I mean, I think we made a good faith effort. We have a good working relationship to try to work this out. We're in the middle of session, so, we can't always do this and have the time that we necessarily want. But I just want to emphasize, just to summarize, 3 things. First, to be appointed, like I said, you have to be named in a valid will, you have to have statutory priority to serve, or you have to have been appointed by a court after notice has been given to all interested persons and there has been a judicial probate proceeding before an orphans court. So that's number one. So it can't just be anyone. Number 2, as Ms. Good said, if it's an estate over a certain value, basically any estate that's worth any kind of meaningful amount of money, they have to qualify for a bond. The bonding agencies, many of the bonding agencies will not, period, issue a bond to a non-citizen. When they do their searches, they'll run a search for their social security number. And if they don't have a social security number, they're not going to be bonded. And even for a native born citizen who has a social security number, if they don't have good enough credit, they won't be considered either. So there's that barrier. The only other thing I want to add is that, again, if you don't live in Maryland, whether you live in Pennsylvania or abroad, you still have to have a resident agent. So that's 3 safeguards right there. And the final 4th I'd add is that any interested person or the orphans court or the register at any given time, if they believe that there is some kind of malfeasance, misfeasance, nonfeasance occurring because of the conduct of the personal representative, can initiate a proceeding to remove that personal representative and have someone else take over the estate. So from my perspective, all of that is sufficient. And if we're just, we may just not have the same outlook on this, but I feel like we have enough.
And there was a reference to what other states do. Could you touch on that? What states in the region do? Is it similar or different?
It's what we have. This bill would mirror what all of our surrounding jurisdictions do.
Members, are there any questions or discussion? No. We can of course table it, but I would also entertain a motion to vote favorably if anyone is so inclined.
So move.
Thank you. Is there a second?
Second.
Thank you. If you could indicate by raising your hand if you are in favor. Thank you. And if you are opposed, please raise your hand. Thank you. I appreciate it. And thanks for being here, everyone. We appreciate you, and you are free to go. For that bill, not our members, because we are now turning to Delegate Cardin's bill, which we discussed last time. And sorry, this is House Bill 65. This is the attorney-client privilege, granting that for fiduciaries. We discussed it last time. I think we came to a level of comfort. So I would open it up. First of all, any questions or discussion? And if not, I would entertain a motion to move favorably. Oh, yes, Delegate Simpson, please.
Yeah, I think you almost got me into trouble with Carden since he like followed me into my office.
I
So he was
saw-
here for the meeting, and I'm like, you can't dismiss us. I'm gonna be in so much
I'm so
trouble."
sorry. I didn't get the link, so I was following. I was stalking. I was
It's
stalking.
fine, but then if she almost let us all go, and if we hung up, I
I'm
thought,
sorry.
oh my gosh,
I'm sorry.
that'll
I'm
be-
sorry. I meant just the witnesses. I apologize.
We're all good.
But does everyone remember this one? And are you comfortable?
If you can just recap
Yeah.
the bill.
Delegate
for me.
Carden.
Oh, here you want. Oh, I didn't know you wanted me to actually work. Okay.
Oh,
I
I
apologize.
can if you don't want to.
I was going to pull up my notes, but why don't
Oh, I
you?
can do it.
Let's go ahead.
So Delegate Simmons, under current law in Maryland, there's some ambiguity about whether the attorney-client privilege attaches to a lawyer who speaks to a fiduciary to the trust. And because there's this old common law theory of the fiduciary exemption, because the trust is arguably, or the beneficiary is arguably the client. But because Maryland case law is heavily inclined towards recognizing the attorney-client privilege, there's many benefits to an attorney-client privilege. Obviously, it allows, candid conversation between the client and the attorney, and it's very common for a fiduciary to want to seek legal advice. It's also consistent with most of the states that have enacted legislation. So after talking through it, at least the concerns I had were alleviated by the member of the bar who had proposed the legislation and spoke at our last subcommittee. But please, anyone add anything if I'm leaving?
But Chair Embry, I'm just going to say that we actually have the Senate bill passed out of the Senate on the 26th, I think. But anyway, the vote was 44-0, and
Okay.
it passed out favorably.
And without any amendment, right?
Exactly. So the Senate bill is already with us, and we're just moving it to send it back over.
Great.
And you did a great job, Madam Chair. Just to reiterate that it appears as if this is the present practice and present law as it stands, or everybody believes it stands in Maryland, and we're just making sure that there's not going to be any rogue decisions that might change that. That's at least what the MSBA would like to make sure.
And there was no opposition.
And there was no opposition.
Right, I saw that. Yeah, thank you. Appreciate that.
Absolutely. Are there any other questions or comments or discussion? If not, I would again happily entertain a motion.
So
Move
moved.
favorable.
Thank you. And I'll take
Second.
that as a second. Great. All in favor, please raise your hands. All opposed? Unanimous. Thank you so much.
you.
Unless there's other business, that concludes our agenda for the Estates and Trust Subcommittee today.
So we can go this time.
So you can really go, and I will be careful about who I excuse.
Delegate Simpson, thank you very much for allowing me to stalk you.
Thank you guys so much.